It. Proceedings are now resumed, and we will now consider appropriations to the Attorney General, commencing with LGA 1, Legal Advice and Representation in Civil Matters, for $2,004,643 in 2018 and $1,923,683 in 2019. Are there any questions? Member from Northside.
Through you, Mr. Chairman, to the Honorable Attorney General. The public lands law allows for the prosecution of persons who block accessways, particular prescriptive access to the beach. How does one go about initiating that process? And what is required in terms of evidence, or do you gather the evidence yourself?
Thank you, Mr. Chair. Just by way of clarification, prosecutions are done by the DPP, but I can assist the honourable member. What I imagine would happen is that if there's evidence of... Sorry, you hear me? Sorry. Yeah, thanks, sir. If there's evidence of obstruction or blocking, as the honourable member referred to, leader of the opposition referred to, then clearly someone would gather that evidence, including collecting statements from persons affected, and that would be turned over presumably to the police, who would then carry out further instructions and then refer a file formally to the DPP's office for consideration.
So it's not your chambers that does the actual prosecution, you would refer it to the DPP. I thought the DPP only dealt with criminal matters.
Well, prosecutions, yeah. Criminal matters are prosecuted. Civil matters, that's different. We do civil matters.
Okay, but wasn't that a civil matter with the blocking of the public right away, or is it considered criminal if you do that?
I'll have to look at it to see whether the law says it creates an offence. If it creates an offence.
Yes, it does.
Well, that's a DPP matter.
And it's punishable by a specified fine.
And that's a DPP matter, yeah.
Okay. Yeah. So, the process, for instance, I have at least 3 that I can think of right now in my constituency that have been blocked by landowners during various things. You're suggesting that I take photos, go to the police station, make a complaint, give them a statement, and then they will process it from there through your office to, it doesn't have to go through the ministry. Because I've made complaints to the ministry, but nothing has happened. I guess I can see why now.
Yeah, but it doesn't necessarily have to go through the DPP's, through the AG's office. It can go from the police directly to the DPP.
Okay. Another question in terms of you providing advice to other ministries and other departments. Do you get involved in advising other departments of government? Well, let me give you, for instance, the Central Planning Authority. The Central Planning Authority grants planning permission in direct contravention of the public land law. How is that dealt with?
Well, I wouldn't expect that the Central Planning Authority would do that, but assuming that it can be established that the planning permission was granted in violation of the law itself.
Well, I think if most of us travel West Bay Road occasionally, if not any more than that, and you will have noticed prior to the seaside wall of the second tunnel, there were some swim signs there which designated prescribed access to the beach, which are now blocked by that wall. So I would offer a suggestion that the Central Planning Authority, in granting permission for that wall to be put up there, is violating the prescribed access to the beach.
But Ms. Honorable Member, has the planning authority itself, or the planning department, confirmed that that was in contravention of the planning law?
Well, all of us that live here, but not in contravention of the planning law, but in contravention of the public access to the beach. Because the planning law, I guess they were looking at the structure and.
What sort of
but those prescribed right of ways on 7 Mile Beach, signage for them was put up, I believe it was in the 80s. So for anybody to pretend now that they didn't know that that's what that, I think it was a brown sign with half a person pretending to be swimming, high elbows, right? The question is who do we complain to in that situation? Is that something that your office would take on as a matter of course and advise them that they shouldn't do that? Or do you require a complaint from somebody about it?
Well, if it is that it is clearly in violation of the law, it's something that we certainly would want to speak to the planning department about. So if you could probably formalize whatever it is that you're
right,
and send it to us.
I have a similar situation in my constituency where it appears that planning has granted permission for a fence, construction fence, to be erected not only across a prescribed access to the beach, but across a registered easement for fire trucks to an existing development. And the attitude is that if the fire truck arrives and the fence, they didn't much just drive over it. And in addition to that, it seems that they have also granted them permission for parking to be across this divide. But if it is necessary for me to give you the specifics, I'll take care of that.
Yeah, but we'll be happy to have a look at it, Mr. Honorable Member. So if you could send it to us, we certainly will take it up with them.
Member Freeston.
Thank you, Mr. Chairman. Mr. Chairman, I guess this question I need to ask the Right Honourable Attorney General is whether or not government departments are required to seek the advice, the legal advice of his chambers.
Mr. Chair, thank you. I wouldn't say that they're required to. I mean, the people who headed up these departments are sufficiently, in my view, savvy enough to know when it's a matter that requires legal input, and they invariably seek our advice in those circumstances. But I'm not sure if there's any sort of a requirement, and this is a real legal issue.
The main thing is, Mr. Chairman, that is his chambers. Is that correct? It is the Attorney General chambers that government departments must receive legal advice from.
Well, the Constitution, I think, in Section 56 of the Attorney General is the principal legal advisor to the government. Principal presupposes, it seems to me, that there could be other people there. But the conventions over the year, and the years rather, and the expectation is that you will go to the Attorney General's chambers as the first port of call.
We have now established that. Thank you. If not, if no legal advice is sought, is it in accordance with the Constitution, being the legal advisor to the government on public matters, is it then the responsibility of those chambers to intervene in the public safety interest?
I'm not so sure I'm following it. If we're not being asked,
if the Attorney General's office is not asked, advice is not sought, and the acts, omissions, whatever, of those government departments encroach on public right, safety, is it the Attorney General's Chamber's responsibility to intervene?
Thank you, Mr. Chair. I'm hoping I understand what he's saying. And the question is whether the Attorney General has a remit to intervene if there's a sort of a breach of statutory duty or something?
Yes, Mr. Chairman.
Right.
Mr. Chairman, the Attorney General has responsibility for chambers, has responsibility for public rights, public, from a civil perspective, public safety on behalf of the government. Is that also the remit of the Attorney General's office?
I wouldn't say we have right due to public safety. Clearly, there's a department that deals with public safety, but if that department refers something to us, which we think that is an issue that requires our intervention, either to get a declaration or an injunction or something on behalf of a department or a public agency, then that is part of our role. I hope I understand what you're saying.
But not if there is something that they are contravening. It's not your place, the Attorney General's place, Mr. Chairman, to intervene.
You mean on our own motion?
Yes.
Yeah. I'm sure there are issues there because the Attorney General is one of our remit is guardian of the public interest.
Thank you.
For example, if there's a charity that is set up for public purposes, and there's a violation of the way it is being conducted, then clearly we have the remit in law, at common law for that matter, and now under the NPO, to intervene on our own motion.
Thank you, Mr. Attorney General. Mr. Chairman, in that same vein then, I understand from the planning, what's it? Commonwealth, Central Planning Authority, that in recently, Mr. Chairman, that they do not consider a beach access unless it is registered. They do not consider it in their deliberations unless it is registered. Keeping in mind, Mr. Chairman, that there are very few beach access in this country registered. What part does the Attorney General Chambers play in that?
Mr. Chairman, let me just caveat my response by saying I'm not so sure exactly of the actual factual situation that the member is referring to. But the little that I recall is that there have been some discussion about at what stage these are enforced. And I think the position is that there are certain procedures to be followed before these accesses can be recognized in law. And it's not quite clear to me whether those steps have in fact been taken, which would then result in these public access being recognized. So, subject to my confirming that, but my understanding is that there are certain steps that needs to be taken before you can have formal recognition. That's what the law requires.
And is that recognition registration?
Sorry? Recognition, stroke, yeah, registration. Yeah.
And registration?
To be registered as such, as a public right way, yeah.
Do we, and Mr. Chairman, I'm trying to get this straight in my head here, and I do apologize to the Attorney General, but Is it in the public interest to register those in law when anything registered in law can be changed? Recognition, but I'm talking about completely different, under the registered land law. Is it advisable to register those? I understand recognizing them and they cannot be encroached upon. Is it advisable to register them when registrations can be manipulated and changed by legislation?
Well, my advice would be that if it is going to be an issue where rights are going to be disputed, then the best way to really get recognition from the courts, or a declaration for that matter, is to demonstrate that these rights, whatever they are registered.
Mr. Chairman, this is asking advice from the Attorney General, or my understanding of this.
Yeah.
Here we are. There could be the possibility of restricting of access thereto, in particular those with that tunnel. How do we get past that, Mr. Chairman, in that hitherto it was unrestricted access?
Mr. Chairman, I am loath to hazard a guess or sort of get into this kind of conjecture, because really we operate based on a set of facts that is put in front of us, and we look at the facts, look at how that squares with the law, and then make an informed opinion or decision based on that. I understand what the honourable member is trying to get at, but I think we're all handicapped here because I certainly am not privy to the underlying facts of all of these things, and I don't think it's helpful or desirable, for that matter, for me to attempt to provide an answer in those circumstances.
Oh, well, Mr. Chairman, I was only doing it as a follow-up with him saying initially, immediately preceding that we should register them, advisable to register them, or a declaration from the court. That's what I understood.
No, usually if a court is going to ask to adjudicate upon rights, then someone needs to be able to point to where those rights are documented or how they came about.
Okay.
And so if it is registered, which is really a system that is recognized worldwide,
Which was
as
in
evidence of rights.
1832, yeah. Right.
Yeah.
Okay, Mr. Chairman, I want to go on to a different one now. Under the okay, go ahead.
Through you, Mr. Chairman, I understand that many of these beach accesses that were earned under the prescriptive law, that is, people have been using them for much more than 20 years. And I also understand that as far back as the 80s, this has been problematic in that evidence has been presented to the various portfolios responsible for the registered land law, but it never ever seemed to come to some kind of final stuff. Is it possible that because these prescriptive rights to the beach have not been registered, although many of them are represented on the maps as little red dots, which I argue is registration, right, from the cadastral maps, that people may lose them now in this transition period to trying to get recognition under the public lands law, because again there seems to be a crawl in terms of the implementation of the public lands law and getting these beach accesses properly recognized, so that we can then appeal because for the people to be prosecuted.
Thank you, Mr. Chair. I think there are two different issues, really. One is the prosecution he speaks about, which is a criminal offense. The other issue, as I understand it, has to do with having these rights sort of recognized and, by way of a declaration by the Grand Court. My understanding, if I recall, is that once the law was amended, there was a commission that was supposed to be set up, a body that was supposed to be set up that has conduct of that. I am told that is either that has been done or they're in the process of, I think Cabinet recently approved the setting up of the commission. And then the next step, if I understand it correctly, is for the administrative framework to be put in place, bodies, inspectors, etc., and then it will be taken forward. I don't think, Honourable Member, during that process there is any likelihood of anyone being prejudiced or any rights being lost as a result of that taking place. Probably quite the contrary. You're right, if you ask me, would likely to be even more concretized, really.
But as I understand it, there are two types of access to the beach that exist in law in Cayman. One is the traditional ones that were earned under the prescriptive law, which, by the way, also includes the beach up to vegetation, because that was the condition under which it was earned, not up to high water mark. High water mark is a thing established for planning purposes. But we're getting more and more people believing that they own the water now, much less the beach. And the other was under the various forms of the development and planning law. Yeah. If a development is greater than 300 feet along the beach, more than 300 feet or 200, right, they had to leave a 6-foot right away. Now, many of those, which was a requirement under planning, and partly the conditions of the approval for the development, but because of the space, the time factor, when those were granted and people have been using them, they now have a prescriptive right to use those planning access. So, but most of those are the ones that are, the developer themselves have been allowed by the planning authority to erect all sorts of things in them and block them. And nobody seems to be willing to enforce the legislation. That's what I'm asking. If the planning ones, and once you use it for more than 20 years, you now have a prescriptive right which cannot be taken away.
Mr. Honourable Member, as I said before, I'd like to be extremely careful about my answers. I don't know what the answer is to that, because the law requires that before it can be recognized or registered as such, whoever it is that is alleging use, uninterrupted use over the 20 years, need to provide evidence of that. That evidence needs to be documented, collated, documented, and presented. And once it is accepted that that is the case, then clearly the appropriate declaration can be made by the court. And once that is done, then it is indefeasible. And so.
Well, through you, Mr. Chairman, could I ask the Honourable Attorney General to use his good graces to encourage the ministry that is responsible for this public lands law, that there is some urgency in this. I mean, as late as this weekend, I've had complaints of people being told they can't sit on the beach in front of hotels. And I understand they can't use the hotel chairs and other property, but they can't tell them they can't sit on the beach. And they can't tell them they can't walk across, or that they can't go to water either. But it is happening. And we need to get it. We need to get this thing squarely established. Thank you, sir.
Thank you, Mr. Chair. I undertake to do that. Thank you.
Minister, member from East End, then Georgetown Central.
Mr. Chairman, I wonder who the Attorney General can say is responsible for particularly the beach, along the beach now. Would it be the police? If you were, if one is restricted from using beach, not the perpendicular access, the beach, within the high water mark, if one is restricted or one is restricted from using that, who is responsible for the enforcement of that?
Mr. Chair, that presupposes the existence of a sort of a private dispute between the landlord and persons trafficking over what is perceived to be their private property.
That's correct. That's correct.
So if there's an issue there, then somebody needs to take it to court. But I'm sorry. But I'm sure if the ministry responsible for lands and or the planning department for that matter, if they are made aware of that, then it's something that they would wish to look into to sort of see whether they can mediate and bring some clarity to the dispute.
Okay.
Georgetown Central.
Thank you, Mr. Chair. Through you, Mr. Chair. Can the Auditor General, Attorney General, sorry, I apologize. Attorney General say in layman's terms, because many people say high water mark. That's what the law refers to. Can you say for the average person what high water mark means in different wording so the average person knows?
Mr. Chair, there are various variations of what that means, depending on who you speak to. And I'm not so sure that is something that I claim to be an expert or have an expertise in at all. So I prefer not to, if I can, prefer not to proffer an opinion as to what that means, really. And so,
thank you, Mr. Chair. Mr. Chair, through you, that creates a problem for enforcement in the Cayman Islands if we cannot have the Attorney General give the interpretation of, and by all means, I'm not trying to be malicious in any way.
Mr. Chair, I'm happy to get a copy of the law and read what it says. I mean, we're all bound by the four corners of whatever the definition is in there. I'd be happy to get that for the honourable member.
Mr. Chair, and through you again, can the Attorney General then say through you, Mr. Chair, who will give the interpretation of exactly what that means in respect to the law?
We will. We provide that kind of opinion.
So, Mr. Chair, can the Attorney General then say through you why he can't answer it now?
Mr. Chair, I don't walk around with all pieces of law in my head. A good lawyer is not one who walks around with all law in his head. A good lawyer is someone who knows where to find the answer if it's required. And I'll be happy to get.
You're not gonna be good. You're not gonna be lawyer.
I'll be happy to get the law and look at the answer for the honourable member and send it to him in writing if necessary.
Thank you, Mr. Chair. I'd appreciate that commitment to giving us the definition of the high water mark so we can make it public for the members of the Cayman Islands to know what exactly are their rights.
I'll be happy to do that for you, honourable member.
Thank you, Mr. Chair.
Other questions? Member for Northside.
Through you, Mr. Chairman. For some time, we've had some discussions around, and I'm not sure what the correct legal terminology is, but I will call it commissions, of allowing lawyers to take at least part of their payment in commissions as opposed to being able to demand that it be put in pocket as soon as you walk in the door. Because I believe if we can get that change to the law made, it will allow better, or I shouldn't just say better, but greater access by many Caymanians to the justice system. Yeah. Part of their fees can be a percentage of their winnings, or is that likely to come to fruition, or you're not getting necessary support from the legal fraternity to do that.
No, I think let me just confirm. I think, as far as I recall, the Law Reform Commission is in fact looking at that as we speak.
That's the one about the commission, lawyers taking fees and taking commission fees.
Thank you. Yeah, contingency fee arrangement. I'm advised by the former director of the Law Reform Commission that the report on the bill will be completed certainly by the end of this month or shortly thereafter.
All those in favor of LGA1, legal advice and representation in civil matters, $2,004,643 in 2018 and $1,923,683 standing in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. LGA3, law teaching and publications, $1,081,891 in 2018, $1,049,892 in 2019. Are there any questions? Member from East End.
Thank you, Mr. Chair. Mr. Chair, through you, sir. Would the Attorney General agree with me that to get into the law school, to enjoy the reduced tuition, you have to prove you're Caymanian?
Thank you, Mr. Chair. I get that you have to be Caymanian, legal resident, or Marta Caymanian. Yeah, legal resident for 10 years or more, or Marta Caymanian to be able to get the local fees.
Can you can he explain then how does someone married to Caymanian or legal resident allowed to get into the law school with the legal practitioner's law, saying that you have to be Caymanian and enjoy that I'm talking about. You can get into the law school, but you have to pay the larger fees. And you have to be on visa and the likes and what have you. But I'm talking about enjoying those reduced rates. It has, when the law requires you to have a special dispensation from cabinet.
You're talking about the law school itself, or you
yes.
I am not so sure. Well, let me just revisit that. We're talking about two separate issues here.
Two complete.
We're talking about being able to take advantage of the reduced fees.
Yes.
Right. Okay. I'll let the director, through you, sir, answer.
Honourable Member, Mitchell Davies from the Director of the Law School. I think we may be talking about two different programmes. We have the professional practice course, which is reserved only for Caymanians or spouses of Caymanians, as is entering articles of clerkship thereafter. Or the law degree itself, which is a prerequisite to entry on the professional practice course, is open to international students as well as Caymanians, and that's where the fee differential arises. That answers the question.
Okay, yes. I'll go to the PPC then and forget about the
What is the fee differential?
6,000 plus and 14,000 for the degree. So 6,000 came on and 14,000 expatriates.
Yeah, and Mr. Chairman, I understand to get that you have to, and this is not a trick question, it is a lead up thereto.
For the PPC course?
Not a quick trick question, but to what I'm trying to get, Mr. Chairman. and I hope they don't use those caveats again. It is agreed to get those fees. You either have to be Caymanian or have a special dispensation from Cabinet. That's agreed. It is further that to do the PPC, and more importantly, to do the PPC, you must be Caymanian, i.e., to ensure only Caymanian practice law in Cayman out of the law school, or a special dispensation, and we can talk about that. Married Caymanians, whatever the case may be, you're going to be here, so you're entitled to work in Cayman. I am in support of that. There's no need for us to argue that case. Now, here is the real question. I want to know, why is it that when we're going to do, you're going through that Caymanian special dispensation or whatever to do your PPC, you have reached there. They then have to do articleship. Why is it that the law firms are asking for an acknowledgement letter of Caymanianship, Caymanian status? I want to know that.
Good question, but I think it's directed to the wrong person, Mr. Chair, unfortunately. I would imagine that that is an issue of contractual law between the law firms and the persons who are asked to do articles or employed to do articles there. I don't know whether there's an issue under the immigration law that the employer need to satisfy themselves that these persons are in fact Caymanian as they represent themselves to be. I am not so sure why that is a requirement, but
Mr. Chairman,
clearly a private contractual issues between the parties. Yeah.
Mr. Chairman, I don't care where Caymanian came from, whether it's paper, birth, descent, I don't care. Matters not to me. We are one. Once we established that school in the 80s for that specific purpose. Once we have established at that school that that person is Cayman, because they got proved they're Caymanian to get those half price, less than half price. You have established it. It is a given. There aren't 1 million lawyers going to law school. We know who they are. The law firms are also at their graduations. They know who they are.
Mr. Chair, let me just say this to the honorable members. Once you have completed your PPC course and you have gravitated towards or you migrated towards being an article clerk, you're no longer part of the law school establishment. The law school isn't really responsible for you in that regard. You are now an employee, potential employee with a law firm. And I would imagine, as I said again, it might very well be that in order to ensure that they are not in violation of the law and do not require a work permit, the law firms might be asking persons to prove that you're a Caymanian and you don't require a work permit.
Mr.
It is true, Mr. Chair, that in some instances it might sound like a ridiculous question, really, because I am aware the Premier discussed with me, his son had to get some documentation to prove that he's Caymanian. So it would seem to me that somehow common sense seemed to have taken leave of.
Is it not?
No, Mr. Chairman. 1 minute, Mr. Leader of the Opposition. Mr. Chairman,
I'm trying to help you out.
When a person applies to do articleship, they can be nothing but Caymanian or special dispensation, which allows them cabinet. That's the highest office in this country. when they apply to do what? Articleship in the Cayman Islands. That is it. It is no question surrounding the quote-unquote status of anyone doing articleship. There is none. I do not understand why, since they have finished their PPC, that no one seems to understand that that person is entitled to practice law in this country. But more importantly, the school, as hard as we have worked for recognition for that school, the number that has been successful in it, 1, 2, at one time we had about 10 in here. Rightly or wrongly, why is it now that the school is not recognized as being the origin of that education, and they are now applying for, haven't done their PPC on their resume at the Cayman Islands Law School, and Liverpool, whatever they do it at. The School of Law of Liverpool, right? What more does those people need? What you want them to do, dig up their grandparents?
I really don't know the answer. Yeah, I don't have the answer to that, Mr. Chair. I think it is a purely contractual issue between an employer and potential employee, and want to satisfy themselves that they are within the four corners of the immigration law. Yeah.
Are there any other questions?
Yes, Mr. Chairman.
Member for Newlands.
Mr. Chairman, back to my, it's gone from annual question to every 2 years now, but it's the same question. Have we considered adding a GDL program to the law school, Cayman Islands Law School, to accommodate Caymanians who may want to study law, who have a degree already, but are working full-time in most cases, and would like to get a qualifying law degree and move on to practice law? Have we considered adding that to the curriculum?
Can I just ask the director with the permission to answer?
Through you, member. We've had some inquiries from potential students, but frankly, we haven't had many from local students. Somewhat ironically, I think most of the inquiries I've had about that have been from international students who have got a first degree from elsewhere. So the straight answer would be probably we haven't looked into it very much for that reason, to be honest.
Thank you, Mr. Chairman. I think that the issue is you have to flip it around. If you offer it, people would take advantage of it. I don't think that most people are inquiring because they just see that it's not in the list of offered classes. But Mr. Chairman, I also have another question on the staffing at the law school. Are we having issues with high turnover for lecturers and so forth?
Thank you. This year we've had 2 members of staff leave this academic year, which is unusually high. Both members of staff have left for very different reasons. The deputy director, who had been a long-serving member of staff at the law school, as members will probably know, who had been with us for nearly 15 years, she left to join private practice for reasons which I'm sure members will appreciate. The other member of staff left for entirely different reasons. She has remained on the island as well, as I understand, working also in the private sector as a paralegal. So neither of those departures from the law school have caused me any concern in terms of there being a high turnover. I mean, it is apparently a high turnover in the last 12 months, but as they're for very different reasons. It doesn't leave me concerned. And I would say we've replaced them with two very, very strong, experienced academics from the UK.
Thank you. Mr. Chairman, through you, you said 2 this academic year.
Sorry, this calendar year.
This calendar year.
Yes.
Okay.
Yes.
Okay. Well, thank you.
Member for Bodden Town West.
Thank you, Mr. Chairman. Through you, sir, to the Honorable Attorney General. I know that there are some law schools in the region that when students graduate, they can immediately go into practice once they pretty much have passed the exam. Is there a appetite for us to, I guess, create something similar in the Cayman Islands?
Could you just repeat it?
Given into consideration to getting rid of this article clerk, when you do your PPC, that would be considered your bar exam, and you can practice law immediately.
Oh, okay. Honorable member, at Norman Mandel Law School I went to, a number of us went. We don't have articles, but we have to do a 2-year course, certificate in legal education, which is an extension of the PPC that we do here. After that, then you are entitled to be called to the bar and practice. The traditional English system is that you're required to do pupillage and articles and so. And this is basically a spin-off from that. About 4 years ago? Yeah, about 4 years ago, we gave active consideration to no, not the masters, but to have a sort of similar arrangement like the Norman Mandel Law School. And I shouldn't say the profession was split. The profession, the majority of members of the profession came down on the side of wanting to retain articles. And we considered whether we should have a hybrid, whether we could work with a sort of 2-tier system. Suffice it to say, Mr. Chair, that the argument fizzled, and we just left it at that.
Thank you very much, Mr. Attorney General. Ultimately, this is something that falls under your remit. If you had an opportunity to get your way, what would the system look like that would benefit our people?
I think we could have a system where persons choose either they want to do the 2-year chalk and talk course in school, or you choose to do articles. It's entirely up to, a student might want to be given an opportunity to make that election. I certainly benefited from doing a 2-year certificate of legal education course. Myself, the Chief Justice of the DPP, that's what we're accustomed to. That's what the University of the West Indies and the law school run by those, that's what we do. We don't consider ourselves any less a lawyer than those who done articles.
Thank you very much. Just following on through you again, Mr. Chairman. The reason I'm asking this question is that we have created a culture in this country where we have saw it in the immigration system where you needed a key employee to become, to be long enough to apply for PR. So in essence, we were allowing employers to choose who become Caymanians. Now we're literally giving the law firms to choose who become lawyers. And I think if someone wants to be a lawyer, regardless, that is something, and if they can go out and do what they need to do, I don't think we should be forcing them in a situation where if they can't get articles here, then their career is pretty much dead. So it would be, in essence, the people deciding who become lawyers. And I think for competitive purposes, why would someone want to bring someone in to increase in competition on themselves? So I think in the interest of what's best for the country, what's best for the students, I think we need to look at a system where if someone wants to be a lawyer, they can become a lawyer without being subjected to someone else basically bringing them into the system. Anyway, thank you very much, Mr. AG.
Well, we certainly, Mr. Chair, we certainly be happy to resurrect the discussion again. But just for the record, it was we had a combination of law firms or lawyers and students who came down on either side of the argument. Thank you.
Member for Northside.
Yeah. And is there a prescribed curriculum for articles, or do they just do whatever the law firm feels they should do for that 2-year period, and then they go to court?
No, there's a set model. What's the word I'm looking for? Anyway, there's a prescribed sort of system that we use where persons have to do get exposure to seats. That's what I'm looking for. Number of seats. So you have to study a bit of litigation, understudy that is, litigation, civil, corporate, land law, all these things. So you get exposure to all the criminal law. You have to get exposure to all these different areas and so.
What kind of matrix is used to evaluate to make sure that each person is getting sufficient time? Is there an exam after each one of those periods with the law firm that you have, or you just rely on the good graces of the lawyer to say, yes, you did well, or no, you did no?
No, each article clerk has what is called a principal, and they both keep diaries. And so at the end of, say you're required to do criminal law for 3 months, at the end of that 3 months period, the article clerk will submit a file or folder setting out all the things that he or she has done, and the attorney, the principal, go through, make sure that all the objectives, all the goals have been met, and they sign off, and then you rotate on to another seat, and you do some other things, and the same sort of, it continues for 18 months. It's a very structured program.
Yeah.
So.
Who gets punished if the article clerk does not get sufficient grades in that particular area? The principal who's supposed to be teaching her?
No.
Or him or the article clerk?
No, it's not a question of anybody being punished. It is within the article clerk's interest that he or she complete that area, whatever area it is, properly, so that you can have a good grasp of the law. So, worst case scenario, if you, for some reason, fail to complete all that you're supposed to complete within the 18 months period, your articles might be extended for another 3 months to ensure that you complete the program and so. So it is in everybody's interest to ensure that that happens. It's not a question of anybody being penalized as such.
It just sounds rather subjective to me,
yeah, but
and it depends on the relationship that you maintain.
No, it's not subjective. Each firm, as we do, we have a manual that they follow. And it's a very, very structured program. Depending on the article clerk, some complain that is a little bit too intense. Others complain that, others are happy with it. But it's a very rigorous program. But at the end of it all, the principal has to be satisfied that you are now in a position where we can comfortably launch you out on your own and set you loose on the public.
Is it possible to do well and shorten the period of time, or is the 2 years the prescribed amount?
18 months.
18 months.
Well, no. There's a period of abridgment that you can get. In other words, instead of doing 18 months, you might be allowed to do 12 months. But that is usually reserved for persons who may have been working in a law firm before they studied law, or maybe a senior police officer or somebody who had that kind of exposure. We take that into account, so that will count towards the articles and so. But it's usually anywhere between 3 and 6 months credit that you get for that.
Member for Bodden Town West.
Thank you, Mr. Chairman. If they don't have the answer, it's fine. They can send it to me at a later date. But what I would like to know, seeing that the law school is something that's heavily subsidized by the Caymanian public, by the taxpayers, I'd be curious to know if, say, within the last 10 years, we graduated anywhere from 300 to 500 lawyers coming out of school. I would like to know exactly where they are today. Do we track them to see exactly where they are, where they ended up, what purpose they're doing the degree for? Because I would hate to know that in the last 10 years we produced 400 or 500 lawyers, and probably only 10% of them is probably actively, or 20% of them is actively making a living from a law degree. Because if that is the case, then I think we as a public, and especially this body, will then have to decide how we'd want to treat the law school going forward. Thank you.
Well, Mr. Chair, if I might say so, the law school is value for money, undoubtedly. And as to where they are, there's one sitting right here, and they are sorry, and they are within the private sector. They are in different firms and other disciplines. Not all of them, honorable member, choose to practice law. They might do other things, and you have some in the public service as well, prosecutors, civil counsel, the AG's chambers, and so. But I think there's a fair representation of graduates from the law school across the various disciplines in the country, in the island.
Chairman. Through you, Mr. Chairman, the numbers here in the P&E suggest that you're going to have between 45 and 50 law students in full-time LLB degree, but you're only having 6 do the PPC. Does that mean that there are only 6 Caymanians out of that 45 people in the law school?
No, sir, but I'll ask the director to respond. Some of those, when they completed the LLB, they then go off to the UK to finish their studies. And I'll ask him to respond.
Yeah, Mr. Chairman, those figures will include, I think as the Honourable Attorney General has said, a number of students who may not ever desire to practice law. They may want to study a law degree not as a vocational subject, but as a background subject for business or commerce, or, as we've spoken about, politics. And so it's not uncommon for our students to pursue other disciplines apart from law. But also I should add that at the end of the programme, a number of those students will not come through the PPC. They will elect to go to the UK to study professional exams there. So we do tend to lose track a little bit of their destinations if they do that. So the 5 or 6 that would go on to do the professional practice course will be the students who A, want a vocational qualification in law, and B, have studied successfully through the 3 years of the programme, and C, have elected to do the professional exams locally.
Do you have the numbers there? What are your current ratios of Caymanians to non-Caymanians in the law school?
I can't give you the overall numbers accurately. I mean, I would say at least 75–80% are Caymanians. I can tell you as a fact that in the first year intake of 30 students, 28 are Caymanians or long-term residents. We have, 27, 3 international students, meaning students who are studying locally on a visa.
All those in favour of LGA 3, Law Teaching and Publications, for $1,081,891 in 2018 and $1,049,892 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. LGA 4, Drafting of Legislation and Regulations, $919,982 in 2018, $1,022,562 in 2019. Are there any questions?
Yes, sir. Mr. Chairman.
Member for East End.
Thank you, sir. Need I say? I guess obviously yes, Mr. Chairman. The Right Honourable Attorney General is not even looking at me. He knows where I'm coming.
It's because you kept dressing me in borrowed robes, right, Honourable? I mean, right is, anyway, appreciate it.
He knows where I'm going. I hope he doesn't, I know lobster season is open now. I hope he doesn't back up. But legal practitioners bill. I am asking through you, sir, the Attorney General. I didn't see the legal practitioners bill represented in legislation for the coming 2 years in this budget. It may be that it was just an omission, an oversight. And I would appreciate if he could bring us up to date as to whether he still holds responsibility for that piece of legislation or if it is in some other ministry.
Mr. Chair, like any other legislation that comes to this Honorable House, is a government policy as to what is enacted and what is not enacted. The legal practitioners bill, the last attempt was by the Honorable Minister, then Minister of Financial Services. The attempt, yes. The bill itself was withdrawn, and the government has, in my recent discussion with the Honorable Premier, he has undertaken to have the government take another look at it with a view to come up with a sensible compromise that is workable. So it's in the best interest of the profession, the jurisdiction, and stakeholders, really. So that's where it's at the moment.
Mr. Chairman, I shall have to await the proposals that and we await them eagerly. But I should say that Mr. Chairman, if the AG has been following the happenings thus far over the last 6-8 months since the now withdrawn, the total destruction thereof, he would notice that many of those who were advocating for it are now with it opining from a different position, talking about trains crossing and ping pong and all kinds of stuff. I do welcome their comments. I do welcome the opportunity for us to sit down and talk about this, particularly so since we noticed that Bermuda, I think, has made some. I see the quizzical look on your face. Yeah, there was a position taken recently there. But I think we can use those as benchmarks, some of them. And I should say I welcome that. And we should do it within the next 2 years in order that we can put this to rest once and for all. We are ready. I am. I wake up every night thinking about all those leaves I have out in my waiting to get back at this thing. I have folders, 3-inch, 3-binder folders, still. So I look forward to the Attorney General sponsoring this.
All those in favor of LGA 4, drafting of legislation and regulations, $919,982 in 2018 and $1,022,562 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. LGA 5, ministerial servicing and policy advice to the Attorney General, $1,736,172 in 2018 and $1,711,970 in 2019. Are there any questions?
Yes, Mr. Chairman.
Member for Bordentown
Thank
West.
you, Mr. Chairman. Just looking at these numbers, looking at the 2016, 2017, 18-month forecast, and seeing that the run rate is just over $1 million and it's going up to 1.7 million. I'm trying to determine what's driving the 658,000 or 61% increase in annualized costs.
He's Parliament. Students up there.
Mr. Chair, if we just get a minute to confer, if you don't mind. Thank you, Mr. Chair. I am reminded here that the increase is due in part to a new post being created and also the need to fill a vacant post in 2018 in addition to an additional article clerk position that will take us up to 3. And we're also looking for a policy analyst for the anti-money laundering unit, an additional post in the anti-money laundering unit. Thank you.
That would pretty much account for the increase. Thank you, Mr. Chairman.
No further questions. All those in favor? All those in favor of LGA 5, Ministerial Servicing and Policy Advice to the Attorney General for $1,736,172 in 2018 and $1,711,970 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. LGA 6, Financial Intelligence Services, $1,202,077 in 2018, $1,191,777 in 2019. Are there any questions?
Yes, Mr. Chairman.
Go ahead, sir.
Thank you. Similar to the last vote, I noticed that this cost also moved from roughly $630,000 per year to over $1.2 million, an increase of 91% or $572,000. So I'm just trying to determine what has also pushed up that increase year on year. Thank you, sir.
Thank you, Mr. Chair. The honorable members, through you, I am reminded that the increase in 2018 is due to 2 additional financial analyst posts being created in the financial reporting authority, and a slight increase in official travel, and also an increase in the training budget for the financial reporting authority as well. So 2 new financial analysts, increase in official travel, and increase in the budget for training, the training budget.
Thank you, Mr. Chairman. How much are we looking at in terms of training?
30 to 45. Thank you, Mr. Chair. I got it moved from 30 to 45,000, Honorable Member.
Thank you, Mr. Chairman. We're trying to find 572,000. Each of the two analysts are 200,000 in total, 100,000 apiece, and travel is 85,000 extra. We had 300,000. Is the balance like pay stagnation, or I'm just trying to find where the other 272,000 would be? Assuming, of course, the analyst getting paid 100,000 apiece or something like that.
I'm going to make an answer. Thank you, Mr. Chair. I'm going to ask our CFO to briefly explain for the Honourable Member.
Tiffany Ebank, CFO for the Portfolio of Legal Affairs. So when we look at the actual budgeted amount for 16-17, the actual amount was 1.5 million. When we annualize that for 12 months, it's actually 1,021,148,000. So the forecast amount did not include filling all the vacant posts. And so once those are filled, along with the 2 new financial analysts, plus the training and the official travel, the variance actually from budget for 16-17 over 12 months and 2018 is actually only 181,000.
Okay, no, yeah, because what was given to us was 945,000. So
yes.
If you guys are working 1.5 million, then that would make sense.
Right. Yes.
Okay, thank you very much. I'm satisfied, Mr. Chairman.
Thank you.
Member for Newlands.
Thank you, Mr. Chairman. Through you to the Honorable Attorney General, in incidents where your office is asked to investigate based on information coming from, it might be overseas or wherever, but and there's a confiscation order issued, do we at any point in time have a claim to whatever property or whatever is confiscated, whatever funds?
Thank you, Mr. Chair. We do have what is called asset sharing agreement. So if there is a matter that's prosecuted overseas, United States, for example, and we provide assistance by way of mutual legal assistance, provision of documents or whatever, and as a result of the conviction, proceeds have been forfeited, confiscated. If there are no victims abroad, no restitutions to be made, then we are entitled to a share of that proceeds. And that has been regularly honored, Mr. Chair. So we do get quite a bit of money from that. The money goes into the asset forfeiture fund, which you're all familiar with. So we do. So we have such an agreement with the United States. We have one with the UK, and we have one with Canada and India. Thank you.
There are no further questions. All those in favor of LGA 6 Financial Intelligence Services for $1,202,077 in 2018 and $1,191,777 in 2019. Standing part of the schedule to the bill. Pardon? And $1,191,777 in 2019, standing part of the schedule to the bill. Please say aye.
Aye.
Those against, no. The ayes have it. LGA 7, Review and Modernization of Laws, $441,235 in 2018, $432,235 in 2019. Are there any questions? Member for Georgetown Central.
Thank you, Mr. Chair. Through you to the Attorney General. Can he say whether or not there's any current laws that are expected to be changed that are considered outdated?
Thank you, Mr. Chair. The review of laws is an ongoing, it's an ongoing initiative. So the Law Reform Commission, looks at not just laws that are on the books that are outdated, as the members say, but there might be a need for a particular piece of legislation. A need might be identified as a result of a request from either myself or some other agency, and the Law Reform Commission does, in fact, look at that. So there are a number of laws on the books that I wouldn't say they're outdated, but clearly some that can do with modernization, and that is part of the ongoing project of the Law Reform Commission. Sorry.
Member from East End.
Thank you, Mr. Chairman. Mr. Chairman, I know that Attorney General is so good I need to make sure I have my stuff in order before I start. Mr. Chairman, I wonder if the Attorney General can tell us if all the laws of the country has now come into conformity with the Constitution.
All the laws of the country have been?
It conforms with the Constitution as per the requirement of the Constitution.
Oh.
I know it must be read as, but yeah. I'm talking.
Mr. Chair, thank you, through you. We try as much as possible to ensure that all the laws are in compliance with the Constitution. But of course, it doesn't matter how well we do. There are always lawyers who can find a provision which they think might not be in compliance. So to the extent that we can, we have tried to ensure that laws are in compliance.
Okay, Mr. Chairman, I wonder if the Attorney General would side with me on the possibility of passing that responsibility to the Law Reform Commission. Of course, it has to be properly staffed to do this, because we got laws coming out over years in this country. If it would not be in the interest of getting these things done, because I know every time that we bring an amendment to any law, we try to get it in conformity, you know, but there are many other laws that are not. And as you say, you know, those defense lawyers, they love to look for, get a declaration of incompatibility. Is it not in our best interest, Mr. Chairman, that we turn all that over to the Law Reform Commission and let them do it? I mean, propose the amendments, review it, and give it to us.
Mr. Chair, that's part of their general remit, and as I said, they're on the day-to-day day-to-day chores, duties, they would look to see, among other things, whether the laws are in compliance with the Constitution. But the truth is, a lot of the times you just don't know until someone flag a particular issue. I give you an example, Mr. Speaker. We sat here not too long ago and we amended the Health Services Authority Law, Section 12, to deal with the issue of whether negligence claims can be brought against the HSA. And no sooner than we did that, the lawyer was in court attacking that very new provision that we put in as not being compatible with the Bill of Rights. So it is a very fluid issue. And we just don't know from time to time which section of the law or which law is going to be challenged as being incompatible. But so far, I think we have done pretty well. The Bill of Rights came into effect in 2012, and I don't think we have had any, that much declaration of incompatibility. I think we might only have had one.
Yeah, one with the arrest for
Narayan, yeah.
For 72 hours or something. We had to bring it back
That's
for
right.
the 48 or something.
That's correct. Yeah.
Which anyway, I ain't gonna get in that one again. But Mr. Chairman, what I'm trying to determine is, I know it's their day-to-day thing, especially when they're doing revisions, when you're getting the revisions done and the likes, we try to do that to some extent. But should this not be a particular project? I mean, I'm not saying we're going to catch everything, such as the scenario that the AG just painted, but I'm sure if we do it as a project, and I'm going to try and help you here, AG, which is you will proclaim that is unusual, but anyway, I think we should do this as a project and budget for it and allow the Law Reform Commission to hire individuals, and their job is to review all our laws, to keep them to make recommendations and confirm it, and then we do it.
Mr. Chair, through you, as I said, is part of the rolling job description of the Law Reform Commission. And we have a law revision exercise as well, where if certain weaknesses or certain incompatibility have been identified, the Law Revision Commissioner, to the extent that that can be remedied within her remit, will do that, or certainly bring it to our attention. So there are a number of initiatives in place that speaks to exactly what the honourable member is articulating. But thanks for the suggestion.
Try and help him is like pulling teeth. Anyway, Mr. Chairman, I was merely trying to see if I could get him to get this done much quicker and get the front bench to allocate funds to do this as a project and get it done. I don't see nobody there is interested, so I guess not.
Mr. Chair.
Member from Georgetown.
Thank you, Mr. Chair. Through you to the Attorney General. Can the Attorney General say whether there's been any proposed changes to the District Council's law brought to his attention?
Apparently, Mr. Speaker, no, none that we are aware of.
Mr. Chairman.
So,
continue.
Member from Bodentown West.
Thank you, Mr. Chairman. Through you, sir, one of the things I've noticed at the beginning of these documents, the planning estimates, is usually the government outline for plan legislation. Now, one of the things that jumped out at me in the 2016-2017 estimate, which was an 18-month budget, was the public health law. where it has not been updated since 2002. And I noticed it has again showed up again in this year's budget for a 2-year budget. No. Well, yeah, I noticed that too. But one of the things, Mr. Chairman, through you, sir, is that the whole and enough food, there's no set law, and a lot of standards have changed since 2002. And we're kind of really wondering if there's a commitment or a prioritization in terms of these 8 to 9 pieces of legislation. I doubt all of them is going to happen in 2 years, but at least is this one law that has been given a priority to get it updated, because handling food is quite important. Thank you, sir.
Yeah. Thank you, Mr. Chair. I am advised that there is a food handling bill that was being worked on, and is something that is likely to be hopefully be given some priority in the coming year. And so, thank you.
All those in favor of LGA 7, Review and Modernization of Laws, $441,235 in 2018 and $432,235 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
Those against, no. The ayes have it. OE6, Contribution to Caribbean Financial Action Task Force, $60,000 in 2018, $60,000 in 2019. Are there any questions? 60. If there are no questions, Okay. OE6, Contribution to Caribbean Financial Action Task Force, $60,000 in 2018 and $60,000 in 2019. Standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. EI 34, Portfolio of Legal Affairs, $20,000 in 2018, $0 in 2019. Are there any questions? All those in favor of EI 34, Portfolio of Legal Affairs, for $20,000 in 2018 and $0 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. Members, this concludes the appropriations to the Attorney General. Attorney General, you have any final comments?
Thank you, Mr. Chair. As ever, I wish to thank honorable members for their support for the budget for the Portfolio of Legal Affairs. Thank you. I wish to also thank my staff.
Members, we are next going to consider the appropriations to Cabinet on behalf of the Chief Justice. While we make the change, let's take a 5-minute break.
Mr. Chair, they are here. Oh, yeah, Susan is here. And so is the DPP. They're all here. Yeah.
That's fine. Let's move forward with these appropriations.
I don't know who's next.
Want me to take them first? Members, I've been as we consider this, what I've been asked to do, if we could just take the appropriations to Cabinet on behalf of the Office of the Director of Public Prosecutions first. There are 2 items there for consideration. DPA 1. Okay. I'm happy to put the questions. All those in favor of DPA 1, Prosecution of an International Cooperation, $3,802,122 in 2018, $3,802,533 in 2019, and EI 60, Office of the Director of Public Prosecutions, $30,000 in 2018 and $15,000 in 2019. All standing part of the schedule to the bill, please say aye.
Aye. Aye.
And those against, no. The ayes have it. That concludes the appropriations on behalf to Cabinet on behalf of the Office of the Director of Public Prosecutions.
Mr. Chair, the DPP's office would like to extend its thanks to government for the continuing support in the budget. Thank you.
JAD 1 to 8? Okay. Up to 4. Okay. Been indicating, so I'm going to put the questions for JAD 1 through 4. All those in favor of JAD 1, administrative support to the judiciary for $1,610,028 in 2018, $1,690,713 in 2019. JAD 2, support for court proceedings, $4,799,285 in 2018, and $4,829,443 in 2019. JAD 3, collection of revenue, $608,671 in 2018, and $566,052 in 2019. JAD 4, financial management of court funds, $334,016 in 2018, $315,782 in 2019. All standing part of the schedule to the bill. Please say aye.
Aye.
And those against, no. The ayes have it. HEA 8, autopsy and coroner services, $240,000 in 2018 and $247,200 in 2019. Are there any questions? Yeah. I think that what I'm hearing is that from my chief, the courts request this stuff of the HSA and pay a fee for the service that they provide. All those in favor of HEA 8, autopsy and coroner services for $240,000 in 2018 and $247,200 in 2019, standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. NGS 2, legal aid services, $2.6 million in $2,600,000 in 2018, $2,500,000 in 2019. Are there any questions? Member for East End.
Thank you, Mr. Chairman. Mr. Chairman, may I ask through you, the Attorney General, how many lawyers do we have on this register now, to which the legal aid register?
Thank you, Mr. Chair. Through you, I'm going to ask the court administrator to assist the committee. Thank you.
Through you, Mr. Chairman, Suzanne Bothwell, court administrator. I don't have that number at this point in time, but I can say that all registered attorneys can, in fact, come onto the legal aid register and they can be legal aid attorneys. It is generally a matter of whether they want to engage in that kind of practice. But the list is quite extensive, I can say that.
Yes, what?
The list is quite extensive.
Mr. Chairman, I thank Ms. Bothwell for that. I know there was a time that they didn't want to do it. I hope
It's not a lucrative business.
it wasn't as lucrative as they wanted it, as they would have liked it. That was my question, flat. If it's still at the same price it used to be, what was it, 135 or something like that per hour?
I think we had agreed that it would be increased to 165 per hour. Yeah.
165. Obviously, we also thought and proposed one time that we would ask those who did not participate, like law firms.
Because you like to raise controversy.
Mr. Chairman, we did, I think, played with the idea to propose, or we proposed, that those law firms who were reluctant or didn't want to come in and had better things to do would contribute to this legal fund, this legal aid fund. I don't know if that gained any traction.
Mr. Chair, it is true. It was an idea that we flirted with some years ago when we were revising the legal aid law, but it never gained much traction. As a matter of fact, I'm bold to say there was quite a bit of opposition to it, and so we abandoned the idea, really.
We must find it ourselves. It's our criminals, I guess, but our people who encroach on the law, and I guess we have to find it ourselves. Now, it's more reason why that legal practitioners bill needs to be modernized right now. That's more reason.
Member for Borden Town West.
Thank you, Mr. Chairman. Through you, sir, to the Honorable Attorney General. Is there any firm, I noticed that the forecast for 2016-2017 is 3.9 million. Is there any one firm or one lawyer or whatever that is basically making more than 15% of this total amount?
I'll ask.
All I can say is that there are firms that regularly apply for legal aid funding on behalf of their clients. The category of firms are the smaller law firms and sole practitioners. Whether or not they get a certain percentage of the fund is based on their clientele, and we have to remember that applicants can ask for which attorneys they want, and they might have an established relationship with a specific attorney from a specific firm.
Thank you, Mr. Chairman. Through you, just as a follow-up and just to make sure, none of the Tier 1 or Tier 2 firms are dominant. I just want to make sure that none of the Tier 1 or Tier 2 law firms on Island are the ones that are dominating or have a dominant position in this market. Just to make sure that the smaller guys at least get something.
Yeah, as I indicated previously, it depends on who makes the application. If an attorney comes in and makes an application on behalf of their client, then that attorney will obtain legal aid, and the limits will be capped to the appropriate application. Likewise, if the individual applies for legal aid, they can ask for whatever attorney they would like from a particular firm. So the legal aid director actually has very limited jurisdiction to assign legal aid to an entity or a firm or a practitioner that the applicant doesn't want.
Yeah, thanks. Mr. Chair, just to follow up, as far as I'm aware, through you to the honorable member, none of the bigger firms has any monopoly on the legal aid budget. Not at all.
All is in favor of NGS 2, legal aid services, $2,600,000 in 2018 and $2,500,000 in 2019. Standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. OE1, personal emoluments for the judiciary, $2,015,126 in 2018, $2,076,778 in 2019. Questions? All in favor of OE1, personal emoluments for the judiciary, $2,015,126 in 2018, and $2,076,787 in 2019. Standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. Okay, thank you. I put it. All those in favor of OE4, judiciary expenses, $1,451,294 in 2018, $1,506,276 in 2019. OE43, depreciation of judicial executive assets, $219,025 in 2018, $219,025 in 2019. OE57, executive bank charges, $4,000 in 2018, $4,000 in 2019. OE65, Court of Appeal expenses, $556,555 in 2018, and $582,714 in 2019, all standing part of the schedule to the bill. Please say aye.
Aye.
And those against? No? The ayes have it. OE102, new courthouse project, $200,000 in 2018, $200,000 in 2019. Are there any questions?
Mr. Chairman, do you want to tie those two together?
I'm happy to take the put.
The new courthouse, I mean. No, but I want to ask some questions on both of them. And mine is very simple, sir.
You're speaking specifically of OE102 and EA145?
145. You know, you could take the two of them in succession.
I'm happy to take them in succession then.
Okay. Mr. Chairman.
Let me just clarify something.
Member from East End, can't you just give way to the AG for 1 second?
Okay. Sure.
He wants to combine EA145 with what you're asking, the 320,000.
It's all about the new courthouse.
Right. I just need to make a slight clarification there, Mr. Chair. I'll let the court administrator speak to it, but I think we need to take the word new out of the equation.
Thank you, Mr. Chairman. OE145, we're making a request to amend, EA145, making a request to amend that just to read courthouse. The appropriation for that relates to the existing courthouse, in particular the generator, etc. And the OE102 is the only appropriation for the new court facility.
Okay, so Mr.
We'll
Chairman,
take them separately.
that is an executive asset, and I was going to ask about that. What kind of asset you have when you're not built it yet? But anyway, I didn't want to. Anyway,
we'll take OE102 for new courthouse project.
New courthouse project.
$200,000 in 2018 and $200,000 in 2019. Are there questions?
Mr. Chairman, my question is, every year we do the same thing. What is $200,000 getting us? Hello to the architect.
Through you, Mr. Chairman, the $200,000 that has been assigned to the appropriation assigned for the new courthouse in the past was to facilitate the outline business case initiative that commenced in 2016. Those funds were spent, and they were spent reviewing or considering a number of options for new courthouse facilities. And my estimation is that for the next 2 budget cycles, that funding really can only facilitate that sort of investigation. It really cannot move forward or advance the project beyond that of considering of options. And so therefore, the judicial administration will have to make additional representations to government for additional funding next year to advance a viable option.
Okay, Mr. Chairman, I thank Ms. Bothwell. Mr. Chairman, I need to ask then, I know a new courthouse is going to cost this country. However, and it's going to be big money too. However, my preference is to build a courthouse right where it is. If you know what I mean. Go up about 7 floors right there. I know we got to start talking about parking, but nobody else has any parking in Georgetown, but the government got to find it. That's what they got to say. I know that, Mr. Chairman. They got to put undue pressure on government, the members of CPA. We know that. However, I need to know from the AG or Mrs. Bothwell, in that OBC, did we look at, and this may not be the right terminology now, Mr. Chairman, so please forgive me, but I know this jurisdiction has been commended for its judicial system. Stella, well, you part that too? Was there not consideration been given to, and this is the terminology that may not be right, renting out, so to speak, to be the neutral place to hear cases? Because I believe we had one recently where we could recover some of that money. Like even America, where they need those financial cases. And court users' fee or the case may be. Was it ever considered to justify us spending the money to build a new courthouse?
Mr. Chair, we do have a court users' fee, depending on the division of the court, so financial services division, which is where most of the commercial matters are dealt with. There is an initial flat fee and then a daily rate, and it is capped $750 per day. So we do have that sort of arrangement in place where there is a fee that's being paid. So
yeah, but Mr. Chairman, what I'm sorry to cut the Attorney General off, sir, but what I'm talking about, did we explore the possibilities of our neighboring countries like Canada, US, when they want neutral places, what they would pay? I know we're talking $750 per day, but what they would be prepared to pay, and work that into our model?
What I'm not so sure what's meant by neutral places.
When they have large cases,
yeah,
and they need neutral grounds to try them on these financial cases. Mm-hmm. If we're going to build a new courthouse, we should be letting it out to those countries for those types of cases. Should we explore that?
Yeah, Mr. Chair, I don't. That discussion has never, certainly in my to my knowledge, we have never advanced that issue at any of the meetings that I'm aware of. I do know we have an arbitration law, and if persons want to do arbitration in the Cayman Islands, then clearly we see ourselves at the Cayman Islands as a center of excellence for arbitration purposes, and those would deal with some of the big commercial settlements and so. But other than that, no, we don't really have any arrangements where. Sorry, we haven't given any thoughts. To any arrangement whereby persons could come in and have cases done here as a neutral venue, if that's what you get to know.
Yeah, because we did the arbitration mediation as well, and I don't understand because Mr. Chairman, it appears like every time the stumbling block in the way of the courthouse has been cost. And I know it's going to cost us a large amounts of money to do this.
Mr. Chair,
but there must be some way we can justify it by exploring these possibilities and seeing what people would like to do if they're interested.
Through you, Mr. Chair. With respect to the funding of a new courthouse, I submit on behalf of the Chief Justice that it's a balancing of our domestic needs versus our international and commercial needs. Not every division of our court deals with commercial law or allows for persons to come in and third parties to have a neutral place. We have our local family divisions, we have our domestic civil divisions, we have our criminal divisions. And the most urgent need for judicial administration at this point in time is to be able to effectively administer justice to our local people. We have significant backlogs in cases. We have insufficient courthouses, courtrooms. We have insufficient facilities to even allow for our judges to sit on a consistent basis, therefore significantly delaying the administration of justice. So whilst I do appreciate that there may be avenues through which government can look to offset perhaps the high levels of costs in administering justice in the jurisdiction, the primary driver cannot be that nothing is done because we have not found a commercial solution to fund this. Section 9, I think one of the provisions in the Constitution, Section 107, the government undertakes that it will appropriately and adequately fund the administration of justice. So the court, while it is cognizant and highly sensitive to the concerns that government has about funding the new court facilities, the reality is that this initiative has been ongoing for almost 30 years. I have calculated it to be 70 years, 27 years, and the government has spent $1 million. From 2008 to present, I have not actually calculated the amount of money spent on the different machinations of a court facility pre-2008. So we hope that we can engage the government effectively so that our immediate needs can be addressed so that justice may be administered effectively to our society. And certainly that we are given bridging needs, and then we can talk about perhaps what the long-term solution is to allow for the offsetting of costs. But certainly finding a commercial model is not the solution to having new court facilities. Thank you very much.
Mr. Chairman, I support Ms. Bothwell. I know there was a time in 2005, 2009, we were talking about 2001 to 2005 as well, and 2009 we continued it about halfway pond by Jose's, with the police station as well. Then we come up with that there's too much noise from the planes. I believe we need to just build over what is there. Everybody's just going 7 and 10 floors in Georgetown, put it there and dedicate one floor for rental, period, to all international, all and sundry that would like to come to use us for arbitration, mediation, rent. and charge them an arm and a leg out of it too, and pay for it.
Mr. Chair, I spoke to the Premier this afternoon, and he has given his undertaking to engage further to see what's the best and the most affordable model that we can come up with to address the needs of the court. Thank you.
Mr. Chair.
Member for Northside.
Yeah, but through you, Mr. Chair, but it can't make any sense to continue to spend $200,000 a year looking at alternatives. Exactly. I mean, if we did spend $200,000 in 2016-17. Now we're spending $200,000 in 2018. We're going to spend another $200,000 in 2019. That's $600,000.
I think
to develop a business case.
Yeah, I think, Mr. Chair, what had happened there is that I think an outline business case was looked at, and it came back with figures ranging as high as, I think, a maximum of $177 million. That, of course, is not something that is, in the current climate, is affordable. So the government has asked that another look be taken at what is a more affordable model that can certainly meet the needs of everybody. And I think that's where the matter stands at the moment. So there's a commitment on the part of the government to have a look at this again.
Mr. Chair.
And see how we can come up with something more affordable. Thank you.
Mr. Chair. Mr. Chair.
Go ahead, member from Georgetown Central.
Through you, Mr. Chair, not to be antagonistic in any way, but I think the honourable member of the opposition highlighted a very good point in respect to the spending. Now, are we saying the last appropriation was $200,000? Are you saying we're going to need $400,000 now to look at it again? Or are we saying, see what happens in 2018? If we don't get it right then, take another $200,000 in 2019? Because it has to be a reason for the money. You can't just put it there in hopes. You have to know we have to have an idea of what to expect. Are you saying to this committee, through you, Mr. Chair, that we don't have a plan and we're just allocating money to explore?
Well, through you, Mr. Chair, as I said, the undertaking is that this money is being appropriated now, and the expectation is that the next time we gather here to discuss this issue, there would have been some meaningful things that would have been accomplished. So, to the members concerned, it is true that you need tangibles, and we're hoping that this time around we can come up with something that is acceptable to everybody and is within the government's budget, and something they can afford.
Thank you, Mr. Chair. And through you again, I understand what the Attorney General is saying, but what I understood that was said to this committee is that we spent $200,000 in the last budget, and we came up with suggestions to build a new courthouse, which was unacceptable. So we did one case study for $200,000. We're going to do another one, and we're not going to come back here again in respect to Finance Committee until 2 years from now. So we're going to do another one, which is double the amount. Are you saying that we're going to do a case study in 2018, and if that works, then we don't need the $200,000 in 2019? I want to know which one it is. Is the next case study going to cost $400,000, or we're going to stop when we find the right one? Because I'm not quite getting.
Understand the member, through you, Mr. Chair. If I understand the member correctly, the fact is that the hope is that by the time we get around to 2019, we would have had all of it sorted out in terms of the model that the government can afford. And so that would put an end to the need for any further appropriation for exploring what's the best model.
Mr. Chair, my last question, just straight yes or no question. Is this exploration going to cost us $400,000?
I can't say, Mr. Speaker. This is all appropriation that's put in there as an estimate, and so we're hoping that it will be somewhere within those ballpark.
Member from Northside.
To you, Mr. the Attorney General, would it, or could it be possible that it would be a better use of this $200,000 is to rent more space and equip it to be used as a proper courthouse, because there is some space around here that should be going rather cheaply now, and get so that we can bridge the gap that Ms. Botha was talking about, because we have to find a way to deal with this backlog if we're going to wait 5-6 years to get a new courthouse.
Thank you, Mr. Chair. To the Honourable Leader of the Opposition, I'm told that that is one of the options that is being looked at as well. That's among the options being looked at.
I don't know why it's an option. Why don't you just do that?
All in favor of OE 102, new courthouse project, $200,000 in 2018, $200,000 in 2019, standing part of the schedule to the bill, please say aye. Those against, no. The ayes have it. EI 21, judicial administration, $250,000 in 2018, $125,000 in 2019. All those in favor of EI 21, judicial administration, $250,000 in 2018, $125,000 in 2019. EA 145, courthouse, $320,000 in 2018 and $125,000 in 2019. All standing part of the schedule to the bill, please say aye. And those against, no. The ayes have it. Members, that concludes the appropriations to the Cabinet on behalf of the Chief Justice. The next appropriation is to the appropriations to the Public Accounts Committee.
Thank you, Mr. Chair. Just
sorry.
Want to thank the Court Administrator for her assistance to the committee. Thank you. Thank you.
Okay. I'm going to put the remaining appropriations to the vote. Okay? All those in favor of ADO 2, Services to the Legislative Assembly and its committee, $735,000 in 2018 and $760,000 in 2019. EI 18, Cayman Islands Audit Office, $31,000 in 2018, $10,000 in 2019. OBM 1, Public Interest Investigations, $2,092,381 in 2018 and $2,092,264 in 2019. And EI 75, Office of the Ombudsman, $110,000 in 2018, $50,000 in 2019. All standing part of the schedule to the bill, please say aye.
Aye.
And those against, no. The ayes have it. Honorable members, we have now reached the end of our detailed considerations of the items in the schedule to the bill. But there Members of the committee, can we take a brief suspension? 5 minutes. Just ask if you stay in your seats or within the immediate area so we don't waste too much time when we have to call you back. We'll take 5 minutes.